In this module, we'll talk about who is protected under the law. It's important to note that a student with an impairment may find different legal protections depending on which legal theory is being applied. Furthermore, the reason that a student with an impairment might not necessarily be viewed as, quote, disabled, end quote, within a particular statutory definition, even if the individual is covered, is the level of protection may depend on whether constitutional or statutory questions are at stake. Let's take a look at the types of scrutiny applied to constitutionally based cases. When a claim of unconstitutional action is made, two factors determine the level of scrutiny applied to practices and policies of the state. One, if the individual is a member of a protected class, and two, if there's a fundamental right at issue. Different cases might apply different kinds of theories: strict scrutiny test, the rational basis test, or even the heightened scrutiny test. It just depends. As a practical matter, the Constitution is rarely used as the basis for special education claims because of the difficulty in proving and winning a case under such a theory, and because IDEA, Section 504, and the ADA will usually provide the relief being sought. Let's talk for just a moment about eligibility. So who's protected under the IDEA? Well, the IDEA uses a categorical listing. This has been amended and changed since 1975, but students have to fit into those categories. In 1990, traumatic brain injury and autism were added to the list of categories. If a student with a disability doesn't require special education, but only needs related services, that student is probably not covered under the IDEA. But the school is required to provide specific accommodations. Students between the ages of 3 and 21 are eligible for basic coverage under the IDEA. Incarcerated individuals have some special requirements. What about infants and toddlers with disabilities? There are additional grant funds available to states that provide special education to students outside the ordinary age eligibility years. What about Sections 504 and the ADA compared to the IDEA? Coverage under Section 504 and the ADA is actually much broader than under IDEA. Students who don't necessarily need special education and related services, but still have a disability under those definitions, are still entitled to non-discrimination and reasonable accommodation. Students identified with gifts and talents aren't covered under the IDEA. This was a policy decision based on resources. Many states have provided for coverage for this category within their special education programs, and these students are eligible for the procedural safeguards in those states. Students with ADHD can be covered under IDEA, but not under a specific category for that. They may be covered under OHI or other health impaired. Students in private schools can be eligible for services under IDEA, but the financial responsibility and required services to the student depends on whether the parents or the school place the students. The 2004 amendments clarified this. Students who are incarcerated in the criminal or juvenile justice system are also eligible for special education. There are some challenges to the safety of educational personnel and also in identifying these students in these settings. A couple of additional things you might consider and do some research on this week would be to look into whether or not your state or local education agency has a policy on services for students with gifts and talents. Something else you might consider is, does our state or local education agency have academic qualifications for eligibility for extracurriculars like athletics? Have a great week.